friends, honoured guests, members of the college. They are not mutually exclusive categories, by the way, but I hope in one way or another they include everyone who's here this evening. I want to extend a very warm welcome to all of you to this year's Howarth and Smith Lecture. I'm Frances Lannon, Principal of the College. It's very nice to see everyone here, to welcome people to LMH, and in many cases, to welcome people back to LMH. Good to see you again. We're honoured this evening, of course, to have a wonderful lineup of speakers. Professor Dick Howard, Lady Justice Arden, Suzelle Smith, and Don Howarth. And Don, in a moment, will introduce our speakers properly, but I just wanted to say how wonderful it is to have you here. And I do want to say just a word about Howarth and Smith. So, Suzelle Smith and Don Howarth are founding partners of Howarth and Smith, which is a law firm in Los Angeles. They've been connected in one way or another with the college for a long time because Suzelle did graduate work here. Their continuation of association with the college has been really lovely for us. They run a great internship program for LMH students in their law firm in Los Angeles, which many of our students have benefited from. They're donors to the college, they're visiting fellows of the college, and for, I think, almost 20 years now, they have led and sponsored these lectures. Over the years, I've learned just a little bit about the way they go about their work as lawyers. They do an awful lot of research, they're very thorough, and they're very clever. So if you were to find yourself in a court of law when they were also present, I would just urge you to have taken great care beforehand to have them on your side and not arguing against you. So these lectures have been splendidly interesting, covering many different aspects of the law and the relationship between the law and all sorts of other things, including Hollywood. Today, unusually, the Howarth and Smith gathering this evening is returning to last year's topic because it was such an important topic and inexhaustible, it being Magna Carta. And Don will tell you more about all of that. Thank you.
Well, before I introduce you to Magna Carta, which needs no introduction, I'm sure, to most of you, I want to fill out a little of the background of this star-studded panel because we really do have a wonderful panel for this subject tonight. Professor A.E. Dick Howard will be our first speaker. He is the named professor of law and public policy at the University of Virginia Law School. He received his law degree from the University of Virginia after reading PPE here at Oxford as a Rhodes Scholar. He then clerked for our Supreme Court for Justice Black, and he's written about Justice Black, I think some of the most insightful comments on his career. He is also remarkably the primary architect of the present Constitution of the state of Virginia. There was a referendum there in 1971, and Dick Howard essentially wrote and implemented that Constitution by, I think, a vote of 3-1. It passed by 70-some%. He has also had a strong hand in writing the constitutions of Brazil, Hong Kong, the Philippines, Hungary, Czechoslovakia, Poland, Romania, Russia, Albania, Malawi, and South Africa. I understand he may be available if Scotland needs one. He's also written more about the Magna Carta, I think, than any living scholar. His book in 1968, The Road from Runnymede, is the seminal work in the United States on the Magna Carta. So we're delighted to have him here today as our first speaker. And I'll tell you, after introducing Justice Mary Arden, what each of our speakers will cover in sequence. We're also very, very pleased. Lord Mance is here with us from the Supreme Court, and his wife, Lady Justice Arden, is our key speaker on Magna Carta here at home, if you will. She has a law degree from Cambridge and then an advanced law degree from Harvard. She and I were contemporaries there. She finished there in 1970. I was always a little behind. I finished in 71. She was a Kennedy Scholar there. I followed her in that as well, with a Kennedy Fellowship at the School of Public Policy. She was then starting her career as a barrister here, became Queen's Counsel in 1986, and then was appointed to the High Court in 1993. She was appointed to the Court of Appeal in the year 2000. She is, or has been, chairperson of the Law Commission, 1996, chief judge on the Commission of Constitutional Reform, and the first in her two-volume set, Human Rights and European Law, was published this last January. The second volume, I think, is forthcoming later this year under the joint title, Shaping Tomorrow's Law. She is the head of the International Judicial Relations for England and Wales and a member of the Permanent Court of Arbitration in The Hague. So we really do have a star-studded panel today. Suzelle Smith, I think, doesn't need further introduction. She was a student of Dick Howard's at the University of Virginia. She studied here at LMH and has spoken previously on this topic and on many others as an accomplished trial lawyer as well as a popular speaker in the United States. The way that we have divided up the subject today, some of you who were here last year know that we took just a little sliver of the Magna Carta and we talked about due process, substantive due process, so just one little piece of it. Today we're taking a bigger view, and I want to look at the big picture. This is the key language from the Magna Carta that most people think of when they think of what were the protections or the rights in the Magna Carta, that nobody shall be taken except by the lawful judgment of his peers and by the law of the land. So when we think of the key provisions of the Magna Carta, just to put us in context, we think of the rule of law, due process of law, limitations on government, the king, the government was not above the law, and trial by jury, a little more now in our country than in your country, but still trial by jury. And I want to call your attention, just in getting us warmed up, to this quote by one of our speakers. Magna Carta, Professor Howard wrote, was a bargain struck between King John and the barons who had their own interest at heart. Now, that, I suggest to you, is something to keep in mind as you listen to the development of what's happened since then. Because this is not unusual in the law. I just picked two examples from our Supreme Court. Often in the law, what brings about the development of law, what brings about some of our most important principles and the refinement of them, is when there are powerful views on each side which conflict. They may move in ether for some period of time, but when they conflict, and when those are brought together like tectonic plates, they often give us uprisings that are significant in the law. It's best illuminated, as one of our cases said, by the collision of genuine advocates. So it's not so much about what they may have had in mind in this truce they struck, but by the seed that they planted there. So what we're going to do today is start with Professor Howard, who will give you, I think, a very good overview of what happened to that seed that was planted here when it was transformed to the other side of the pond, if you will. Then we'll hear from visiting fellow Suzelle Smith on the specific perspective of a trial lawyer today in the United States. What practical difference does it make? These protections of Magna Carta that we often see illuminated and written on high, what does it take what does it mean when it's down at the nitty-gritty of daily practice of trial law? And then finally we come back to the US, Meanwhile, at home, to Great Britain, meanwhile, what happened at home after first looking at the transplant, if you will, and see what Magna Carta has meant here, and some of the current issues, perhaps, from Lady Justice Arden. So I think the panel is uniquely qualified to do this, and we'll have a short Q&A session before we break for drinks that I will moderate after we hear from the speakers. So with that, I'd like to introduce Professor Dick Howard to begin the Magna Carta.
Thank you, Don, for that gracious introduction and very lucid beginning to our program. I want to thank Lady Margaret Hall for their hospitality, and Frances Lannon in particular. This is really her evening in so many ways that we can appreciate. We mark, as you know, Magna Carta's 800th year. That's long shelf life in anybody's business. And there's so many great themes of Anglo-American jurisprudence that flow from Magna Carta. You think of the rule of law, you think of due process of law, you think of the organic evolutionary quality of the common law itself. You also think, and I especially want to talk tonight about the principle of constitutional supremacy, the idea of a superstatute, the idea of fundamental law that's superior to other law. That's the one I'd like to make my subject tonight, and in particular, how it shaped American constitutionalism. I should add for my friends here at Lady Margaret Hall that I was at one time as an undergraduate at Christ Church, a frequent visitor to LMH. My purposes were probably a little less academic in those days than they are tonight, so it's nice to be back with a serious purpose in mind. I'm going to skip over the first 400 years, the 13th through the 17th century, on the theory that all of you who are from the UK in your school days thoroughly imbibed Bad King John and the sequels to that. I want to pick the story up in America. In the early 17th century, when the Virginia Company Charter of 1606 was issued in London, and among the provisions of that charter, most of it was a commercial document. Stock shareholders thought they'd make some money in Virginia. They didn't, in fact. But one of the most interesting features of that charter was language which guaranteed the immigrants to Virginia the privileges, franchises, and immunities that they would have enjoyed in the mother country. The idea being if they pulled up roots and went across the ocean to this unknown place called Virginia, they didn't leave their rights behind. Now, one might well conjecture, and historians have, what were those franchises, privileges, and immunities, but whatever they thought they meant when the drafters of that language put it down in the charter, the colonists in Virginia and the other colonies took that guarantee seriously. That same guarantee showed up in the other charters as well as the Charter of Virginia. It really became boilerplate in the original charters. Now, that language was reinforced by a number of procedural mechanisms, appeals in certain judgments from the colonies to the Privy Council in London, requirements in the charters that ordinances passed by colonial legislatures had to be consistent with English law, and hundreds of them were in fact reviewed in London. So you really, from the beginning, began a tradition of Americans understanding or sensing that there was a kind of external standard by which ordinary law was measured. Fast forward to the Revolutionary period, that was the 17th century. When you move into the latter decades of the 18th century, the years running up to the American Revolution, some interesting things began to happen. And one pivotal moment was an argument made by James Otis in a court in Boston in 1761. Otis represented Boston merchants who were objecting to writs of assistance, which were in effect a kind of general search warrants. They were not specific warrants for this particular item or place, but they were sort of open-ended invitations for magistrates to go into a merchant's home or place of business and search for anything they liked. And in making his argument against those writs, James Otis invoked Magna Carta, and in particular, judgments of and commentaries of Sir Edward Coke. Coke, as many of you know, was the leading constitutional legal commentator of his generation in the early 17th century in England. It was he in Parliament who held up Magna Carta as a bulwark against the pretensions of Stuart monarchs. But also in court, there was a case in 1610, Dr. Bonham's case involving the College of Surgeons. And in it, this was dictum, I accept, but in it he said that an act of Parliament that was against common right and reason, the common law would nullify that and make it null and void. Well, historians have debated, lawyers debate exactly what that was meant to be. Was it really something that would supersede law, or was it kind of a canon of construction? What was it? It was dictum. Whatever it was in England, it certainly became something in America. On the English side, I mean, I think citations to Bonham's case tended to die out, so by the early 18th century, it's not really cited in the reports. But on the American side, it became a part of American constitutional law, so that in the run-up to Revolution, Americans, in a way, were beneficiaries, legatees of Coke, perhaps more than their counterparts in England. When Otis made his argument in Boston, he basically was making a constitutional argument, very recognizable to modern Americans. He was saying there is a law, and he cited Magna Carta in particular, that trumps ordinary law, even an act of Parliament. Now, on the English side, this was utter nonsense. I mean, the Lord North and his cabinet, King George and all the others, they couldn't figure, what are these crazy Americans talking about? What do they mean? By this point, Blackstone's commentaries had appeared, and Blackstone says if Parliament wants to do something, it can be unreasonable or bad as you like, but it's Parliament's call. They're the ones who have the final shot. Well, you can see at this point a fundamental divergence between a mother country concept of Parliament supremacy and the American colonist conception that even Parliament was bound by Magna Carta and by the common law. Well, after Otis's argument, then the 7 Years' War, and as you called it on this side, the French and Indian War on the other side, came to a conclusion, successful from the British standpoint, but very expensive. It cost a lot of money. Parliament, not unreasonably, from their perspective, say, look, we protected the colonies on their frontier, they should pay for it. And so they passed the Stamp Act. 1765 was the first measure of Parliament which sought to impose an internal tax in the colonies. Well, I think it's a century and a half after the first settlements. By this point, the colonies were really pretty used to running their own affairs. So they were outraged by the Stamp Act. And they, in particular, when they passed resolutions in the Stamp Act Congress, there were two main points of objection. One, no taxation without consent. Became the great battle cry of that era. And the other was the denial of trial by jury, because these revenue cases were tried in admiralty courts where there were no juries. Well, as things began to unwind, you had the Boston Tea Party, some hotheads in Boston opposing British policies. Parliament, or the British government, closed down the port of Boston. Other colonies came to Massachusetts' support, and there was an outpouring of resolutions and tracts and pamphlets, all of which centered on the same theme, namely, here rights of Magna Carta and the common law and the British Constitution. We were told we had these rights in the early charters. Those rights descended to the early settlers' progeny, to us, the colonists of this day. And you, the British government, are not recognizing and respecting those rights. There was an interesting eclecticism in these arguments. There was an appeal to the colonial charters, a lawyer's argument, here's the language, you said we had these rights. That was mixed then with the Cook, Magna Carta, and the British Constitution, a sort of constitutional argument. And then finally, the mixture becomes pretty heavy because they add in natural law or the Word of God. Now that sort of theological part of the mix ups the ante, doesn't it? We're talking about a truly higher law, something which is given to us by God. And as I read those resolutions, what the colonists were doing what lawyers do in court. They were basically making alternative arguments, but all to the same end. And they would say, you can call it what you like, call it charter rights or Magna Carta or common law or law of God. It all comes down to the same thing. We have rights which you, the British government, are not respecting. Well, of course, the revolution broke out. You all know the story of how that ended, badly from the standpoint of the British government. And then an interesting chapter appears in American history, and that is that in Virginia, May of 1776, group, the convention that was passing ordinary laws for Virginia, raising money and arming militia and the like, they were the ones who instructed Virginia's delegates at the Continental Congress in Philadelphia to introduce the independent resolution for independence. On the same day that they introduced that resolution, or that they passed the resolution in Williamsburg, they set to work on a state constitution. Actually, they set to work on two documents. The story is all the more interesting because first they wrote a Declaration of Rights. It's one of the most famous declarations of rights in world history. Then, having done that, they set to work on a frame of government. I mean, this is pure John Locke. This is social compact reasoning. They're saying, first thing you do is declare your rights, rights that precede government, that are not dependent on government, and then you frame a government itself. Two steps today in Virginia's Constitution, the Bill of Rights is simply Article 1, and that sort of masks the fact that this was a compact theory kind of approach. Well, there was a problem with that Virginia Constitution. The founder of my university, Thomas Jefferson, hated that Constitution. I've always thought he probably didn't like it because he wasn't there. Thomas Jefferson couldn't imagine you could do anything without him. He was in Philadelphia at the time. But he, for the next 50 years, criticized that first Constitution, saying it's fatally flawed because it was drafted by the same body making ordinary laws. That's no Constitution. That's just another law. They could repeal it. It has to be drafted by a separate and independent body. So what we failed to do in Virginia, I'm a born and bred Virginian, but I sometimes give credit to my sister states. Massachusetts did what we hadn't done, namely in 1780. They adopted a constitution, largely the work of John Adams. Samuel Adams, James Bowdoin, John Adams were the drafting committee. The other two decamped to a bar probably and left the work to John Adams, who was the class nerd. So he wrote a constitution for Massachusetts, which was adopted by a convention elected, whose delegates were elected by the people for that special purpose of drafting a constitution, and then the product was put to the people in referendum. So Massachusetts, in effect, invented a concept which Europeans had not devised, which other American states up to that point had not perceived, and that is a body elected by the people drafts a constitution, puts it to referendum, and then you've got what Thomas Jefferson did not see happen in Virginia. So there you have at that point, 1780. This is still before the Philadelphia Convention that wrote the Constitution of the United States. Well, as I say, I want to talk specifically about constitutional supremacy. And what comes into the picture here is it's not necessarily uniquely American, but it has American handprints all over it. And that is the concept of judicial review. I mean, you could, in theory, imagine other ways to enforce a constitution. The French, when they wrote their first constitution, thought the will of the people, Rousseau, the general will kind of thing would come into play. That ended badly for the French in the 1790s. But judicial review, the notion that a court, an independent tribunal, should be the one to enforce the Constitution, really begins its modern rise in America in the 1770s and 1780s. There were a few state cases, Virginia's Supreme Court in particular, they wrote seriatim opinions in those days, and the judges deciding those early cases said, look, this is a constitution, even the legislature is bound by it. The people have ordained it. They said this is the fundamental law. We would be slow to say that the legislature had erred, but if it did, then we would be obliged to say so. That is the road to, all Americans know, Marbury versus Madison, 1803, John Marshall's famous opinion, in which he made clear the power of the U.S. Supreme Court and the courts generally to enforce the Constitution, if necessary, by striking down an act of Congress. Well, you may say, if you read the opinion, you may say, well, that wasn't a hard judgment call at all, because the Constitution has a supremacy clause. It says that this Constitution and all laws enacted in pursuance thereof shall be the supreme law of the land. Well, it says that, but it doesn't say that the courts explicitly have the power to strike down an act of legislature. That had to be inferred from that language. And what I find interesting about Marshall's reasoning in Marbury is not so much the conclusion he reached, which I've just told you, but how he got there. he didn't rest, frankly, very much on the constitutional language that I've just quoted. He really starts his opinion with an appeal to the general principles of jurisprudence. I mean, what is it about constitutions? If you mean it to be a constitution, it has to be enforced. That's the nature of a constitution. And he also said, what's the job of a court? A court's job is to interpret the law, to enforce the law. That includes the Constitution. And then late in the opinion, Cecil and Mary, who studied law in America, will remember reading Marbury for the first time. Towards the end of opinion, he says, oh yes, and by the way, there's a Supremacy Clause. As if it's almost an afterthought in the opinion, as if even without the Supremacy Clause, a court would be obliged to do what he said they had the power to do in Marbury. Well, that's the road to judicial supremacy. Time doesn't permit. I'm just going to give you a hint at what the argument has been about in the centuries since Marbury. And that is, despite Marshall's edict in Marbury versus Madison, there remains a lot of ground to fight over. For example, does the president or does Congress have the same duty to interpret the Constitution? Can they come out differently from the Supreme Court? Do you have a kind of constitutional pluralism? Jefferson, once again, said that they did. What about the states? This is a federal system, a constitutional system in which the states have certain guaranteed rights and powers. Can they get into the act? John C. Calhoun said in his compact theory, said they could. When the southern states, after Brown versus Board of Education, some of them embarked on a campaign of massive resistance to Brown, trying to forestall the desegregation of the schools. The Supreme Court stepped in a famous case, Cooper versus Arden. All 9 justices signed the opinion, and they said, you want to know where the buck stops? It stops with us. We are the ultimate interpreter of the Constitution. And some scholars would argue that what started as judicial review in Marbury versus Madison became, in effect, judicial supremacy in Cooper versus Arden. A last note on the global reach of the idea of judicial review. If you think about world history, if you inquire into the ways in which constitutions operated until World War II, judicial review was really an exception. In most countries that had constitutions depended on parliamentary supremacy, parliamentary sovereignty. The Marbury Principle did not take effect in those countries. I'm fascinated to look back since 1945 on the spread of judicial review. The majority of constitutions that have been written since the World War II explicitly say that the courts do have the power, sometimes a constitutional court, but there is judicial power to enforce the Constitution. There is, as you people in this country know famously, a middle ground. And it's the sort of ground of the Human Rights Act of 1998, which empowers English judges to declare an act of Parliament incompatible with the European Convention on Human Rights. And it's sort of in a middle ground between standing back and doing nothing and the other extreme of Marbury power striking down an act of legislature, which of course is not part of the English UK constitutional system. It'd be fascinating in the next months and maybe a year or so to see what becomes of that particular argument. As you know, it's very much on the table here. So constitutional supremacy and Magna Carta are to me very much related. It's a long road. It includes what Sir Edward Coke had to say in the 17th century, Otis's argument in Boston, the resolutions of the Continental Congress, the early state constitutions and court decisions, John Marshall's decree in Marbury versus Madison, and the battles over the reach of judicial supremacy in the years since that time. Here's what's at play, and I think this is one of those ever recurring themes in constitutional debate, and that is there are 2 fundamental principles that one cares about in a constitutional democracy. One is accountable government. Government elected, whose members are elected by and accountable to the people and can be turned out if the people don't like what they do. That's the democracy side of it. On the other side of it is constitutional supremacy or judicial review, in which a tribunal enforces the Constitution even in the face of popular sentiment. And that's a tension that is inevitable, I think, in a constitutional framework. It's never perfectly resolved. And what it does do is highlight the roles of judges and the uses of judicial review in a way that I think Suzelle will probably turn to now. So thank you very much.
So good evening. I am a lowly trial lawyer wedged between my constitutional law professor, who, as Dawn told you, is one of the foremost authorities on Magna Carta, and following me will be one of your preeminent judges in the United Kingdom. So I'm linking between two erudite ivory tower speakers, and I am here to speak to you for just a very few moments about the more mundane. What does Magna Carta mean to real people, trial lawyers, common people? What is the significance of it in a real world sense? In the United States, Magna Carta is extremely important. And interestingly, I think Mary will address this from a British perspective about how important or not Magna Carta is in the United Kingdom. But to a trial lawyer, Magna Carta, the roots of the American judicial system and the way we present ourselves in our courts in the United States is tied in many ways to Magna Carta. We're celebrating the birthday, the 800th birthday of Magna Carta, with great fanfare in the United States. There are parties all over the United States celebrating this 800th birthday. So the document, the Magna Carta, you know there's several versions of it. Professor Howarth has told you, he skipped over the 400 years of the history, but he told you some of the history of Magna Carta in the United States. These words from the Magna Carta, the most famous in all the versions, which provide that no free man, which has been interpreted, by the way, ladies, to include women, shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled, except by the lawful judgment of his equals or by the law of the land. And those key phrases that I've put in red, the lawful judgment of his equals, is arguably, and Professor Howarth has a slightly different take on this, part of what we trace the trial by jury right to in the United States. Our trials by jury in the United States today are not the same as the 1215 jurors, which is another history lesson, but we have interpreted and taken the right to jury trial and traced it all the way back to 1215. The second phrase is by the law of the land. The common law, the law of the land, which in England was never written down and existed before Magna Carta, but was embraced by Magna Carta as having great power. There's an interesting debate about Magna Carta. How important was it? Was this event when it actually happened? We can talk about Magna Carta from the time of written history and lawyers and Cook and what Professor Howarth talked to you about, how we interpret the significance of Magna Carta using the language, using the precedents, using the court cases as we move forward. But how important was it in 1215? I actually think, and I submit to you, that it was very important. And as a trial lawyer, one of my pieces of evidence is King John's reaction to the charter. King John is reported to have fallen into a violent passion when he was confronted with the words of the Magna Carta. He interpreted the Magna Carta as taking away his power and granting such liberties to the barons and others as would make the king a slave. So King John, even in 1215, did not say, ho hum, what is no big deal about the words of the Magna Carta. My second piece of evidence that Magna Carta was incredibly significant in 1215 is the reaction of Pope Innocent III. When Pope Innocent was confronted with the words of the charter, he exclaimed, historians tell us, "What? Do the barons of England endeavor to dethrone a king? Dethrone a king by the words of a document? And would they force him to transfer the dominions of the Roman Church?" The king supported the church and was the guardian of the church. "By St. Peter, this injury of this document must not pass unpunished. So the Pope and King John did not consider the Magna Carta anything other than a revolutionary, world-changing document. There was a papal bull that said that the barons were making a shameless presumption which dishonored the apostolic see, shamed the English nation for creating the charter, endangered the crusade, the Holy Crusade of the time, on behalf of Almighty God, Father, Son, and Holy Ghost, and by the authority of Saints Peter and Paul, his apostles, we utterly reject and condemn this. The charter, with all its undertakings and guarantees, we declare to be null and void forever. Pretty tough stuff. Tough stuff reacting to the Magna Carta. Well, as Professor Howarth said, why the fuss? What was the significance of this document? Why did King John react to the words? Why did the Pope react so negatively to the words? Because the absolute power of the king, the executive, we would say in the United States, was limited forever. And as a result of the words from those two clauses that I read to you, judgment by your equals and the law of the land ruling, not the law of the king anymore, not the mouth of the king dictating what would be the administrative process, what would be the substantive law. But two modern institutions were launched. They weren't created or born, but they were supported and launched and developed from the Magna Carta, and one is the jury. And the jury in the United States is the defining real decision-making process for trial lawyers in the United States. You, unwisely, in my opinion, have given up the jury trials except in limited circumstances, criminal cases, and I believe libel cases. But in the United States, we trace our right to a jury. It's in most state constitutions, it's in the federal constitution, that we have decision-making power in the people. So common people come in and they are qualified to be jurors. They are instructed on the law by the judges, but the juries in our country are the decision makers. They determine disputes between people in almost all instances in the United States. There are a few exceptions. So because in America, jury right and the right to have our decisions, have our disputes decided by our common citizens and not by a judge exclusively, and not by some educated person who's an expert in the area, but by our own citizens in our country. Because we trace these roots back to Magna Carta, that has made Magna Carta a very cherished and protected document in the United States. The second interesting development from the Magna Carta, and Mary can't see this, I don't think, but the judiciary. The judiciary, that the king would no longer be the source of all law and power, but that this common law, this law of the land, would be developed, and in the United States, it ties into Professor Howard's discussion of the independent judiciary. There are three branches, and it's more complex than that. But the judges in the United States who are independent from the other two branches of government make and develop the common law. The common law is a living creature in the United States and in England. And the judges create that law and interpret that law which they make by the case law and the decisions that are handed down. And that has meant that the judicial system in the United States has been almost uniquely powerful in all the world, because as Professor Howard said, they ultimately, the supremacy of the constitutional law and the Supreme Court, but again on a more mundane level, if you have a dispute with your fellow citizen, you go in and a court and a judge with the common law, not a legislature. The legislature in the United States does pass laws, as you know, but rarely is the individual common citizen going to have a antitrust case, which is a statutory provision in the United States, but a breach of contract case, a negligence case where someone hits you in their car and they've injured you, those cases are brought into court, and the common law that has developed over time in the United States is the ultimate resolution of those disputes and decisions on a very everyday, practical level, which touches the citizens of the United States in very, very real and profound ways. So as a trial lawyer who loves her profession, I am very grateful to the English, the barons who confronted King John at Runnymede and made him sign the charter, because as I submit to you, we can trace back two of the key things that define the trial lawyer in the United States: our right to a jury trial and to present our disputes to a jury, and the common law which has been created by the judges case by case by case over time, separately from the legislature or the executive, which has given the judicial branch of the United States amazing power and a very distinct personality, a very exciting one, and we believe a very just way to resolve our disputes and our problems. So thank you very much, Magna Carta. Happy birthday. And I will now turn this over to the very Honorable Lady Justice Mary Arden. Thank you.
First of all, my thanks to the organisers of the seminar for inviting me to come this evening, and my special thanks to the principal of Lady Margaret Hall for making it all possible to be here. I'm going to, as a third speaker, of course I'm in a slightly difficult position of having two very hard acts to follow. And Professor Howard has spoken not simply about Magna Carta, but about the virtues of having a written constitution. And we don't have a written constitution. We have a constitution which is mostly unwritten, with some little bricks which are now written. So I cannot talk about a written constitution in competition with Professor Howard. But I can, I think, follow on a little from what Suzelle has said about the common law. My thesis this evening is that Magna Carta is the hidden wiring of the common law, the hidden wiring. Now, none of the speakers, I can at least say this, has yet defined for you what Magna Carta is. Indeed, I think I would switch it round and say it's perhaps you to provide the definition. Is it a piece of paper? We saw one picture of the piece of parchment. Can we define Magna Carta as a royal charter executed by King John at Runnymede on the 15th of June, 1215, and guaranteeing certain rights for his subjects? Well, we could do that. It's a slightly flat definition, particularly as we know what Innocent III had to say. Or should we define it rather more energetically, as an event which defines, which is the defining moment in English constitutional history? I'm going to ask you to think about it. Is Magna Carta a document or an event? At the 700th anniversary, a school of thought was developed that Magna Carta was really all myth. After all, they said, Innocent III declared it null and void within 10 weeks. And the subjects for whom the king guaranteed those rights were either free men, i.e. not villeins as they were called in feudal society, and I doubt, or they were either the free men or the barons. So it didn't really protect the rights of all the population. It was a very limited value for a privileged few. And the third point is that we all know, of course, there are only 4 clauses out of the original 62 which are still in force in the United Kingdom. Indeed, I think they probably only in force in England and Wales. The first is that the church shall be free. The second is preserving the liberties of the City of London and various other cities. And lastly, the last 2 clauses, which are generally put together, are the 2 that have been set up on the screen for you, which protect
people from any delays or denial of justice, and which say that people will be judged by the law of the land. So there are only 4 clauses left. So why is Magna Carta so important? Why is it a document which we should think about on the 800th anniversary? Can I just say one thing? It is a document which comes out of the medieval period. 1215, people were only just starting to write things down. And so it is a document which simply writes without any pausing, 62 clauses. They're not numbered. It's a very, very immature document by contrast with what we see in modern legislation. So why is it that we should celebrate it 800 years later? Well, I have a theory about why it is still important and why it has lasted all this time. And each of my reasons begins with the letter R, so I call this the 3 R's. Firstly, it was reissued by the king no less than 30 times. Different kings, of course. It was generally reissued not because the king thought he was going to comply with it all the time, but because it was a bargaining counter. He could offer to issue Magna Carta, and it was gradually decreasing in length, because he could thereby raise a tax from the barons, and he needed the tax to run his wars. So he did in fact reissue it, and that made it constantly a matter which people were reminded of. The second thing that helped it last so long was that it was ordered to be read out twice a year in all cathedrals and in all county courts, district courts. So every year people heard it read out. So twice a year. There wasn't much other public entertainment in those days, and so it was something probably which went into the consciousness of people's minds. Therefore, this is another reason why it has stayed with us. But the third reason is the one which seems to me to be of most importance, and that was, when it was signed in 1215, there was no remedy given to anybody if there was a breach. There was a clause which we call a security clause, which said that if the king broke his promise, there could be a council of 25 barons who could declare that there had been a violation and could then come and seize the king's property. But that was the only way in which it could be enforced. There was nothing in there about ordinary people enforcing the document. And that didn't happen until 1297. But practicing lawyers, seized the moment. They then used Magna Carta in everyday cases in order to enforce rights and improve the law. So we see this great flowering in the 13th, the 14th and 15th centuries of our law, our common law, due to the fact that Magna Carta was there and was available to be used. And by common law, of course, I mean the judge-made law, made every day in the courts, as Suzelle has explained. And one day, when I was thinking about this lecture, I opened some old law reports, and out fell a case called Claygate and Batchelor. I thought I'd just tell you the story. It dates from 1600, and what had happened was that Mr. Batchelor had a son, Robert, who wanted apprenticeship as a haberdasher, i.e. being an expert in textiles and providing the cloth for clothes and so on. And he went to Mr. Claygate, and Mr. Claygate said that he would train Mr. Batchelor's son, Robert. But if Robert should, after the training, practice his haberdashery within 20 miles of Canterbury or Rochester, his father would be liable to pay £30, a very princely sum in those days. Well, Robert obviously did that, and Mr. Claygate therefore sued on his bond for the £30. And what did the court say? They said this is against Magna Carta. For somebody to be bound about where they should work or where they should not work, and therefore this whole thing is null and void. This whole bond is null and void. Mr. Batchelor doesn't have to pay. And they went on to say, you could just think of this, you could just as well bind somebody not to go to church. Just think of it. That couldn't possibly be right. And so what we see in this case, it is only an example, is that the judges were thinking that Magna Carta, in its endorsement of freedom, and they were obviously elaborating on freedom, was creating a form of inalienable right. It was a natural right. A person couldn't bind himself that he would not do something, not work, and therefore be liable to pay a sum of money. It was a penalty. So this was an elaboration of freedom. And I just want to pause there. It's a sort of a development of the idea of natural rights, rights springing from the nature of a person. It's also a development of inalienable rights. And I just wonder if our American friends would recognize the opening words of the Declaration of Rights. We hold these rights to be inalienable. It was a development of the common law. Magna Carta had fed its ideas into our common law and became part of what I call hidden wiring. Now, it so happened that in the 17th century, we developed doctrines whereby you could have reasonable restraints of trade, so that if you did agree to sell your business, you could impose a reasonable restraint because that protected the asset, the business you were selling. And that came about with the expansion of trade. Judges moulded the law in accordance with social expectations. The common law is something that responds to what's going on in society. And what was going on was the expansion of trade, and we needed to have the ability to sell businesses with covenants in restraint of trade. So this story in itself shows a point that Suzelle was also making about the common law. The common law has inbuilt flexibility. It responds from the bottom up. It responds to what people want. And the third point, and I think here it really explores something that Professor Howarth also said, it creates for us another centre of power, power within people to control tyranny in central government, because it's something which springs up from people, and that's what causes judges to develop the law. Now you might just ask this question. I spoke a moment ago about the villeins. Nothing in Magna Carta protects the villeins except one little clause which says they won't have their husbandry tools, their hoes and spades, taken away from them unless the people in the locality think that's right. That was the only protection in all those 62 clauses for the vast majority of people living in this country. But if you search our statute book, there is nothing which says that villeinage, that's the status of being a villain, was destroyed. So what happened? Why isn't everybody now a villain? Well, the answer is, it could be a lecture in itself, that skilled lawyers came along and they recognised that you weren't a villain if you were illegitimate. So what did they do? They developed a process whereby they offered to pay the lord of the manor a sum of money, or got the client to offer to pay a sum of money to the lord of the manor to release a person as villeinage, and then they went to the ecclesiastical courts and they persuaded the ecclesiastical courts to make a declaration as to status, that this person was illegitimate. And hey presto, he was no longer a villain. And you won't believe it, but that's the reason why villeinage died out. It was another development, if you like, of the common law. There we are, judges seeing that villains possessed a status which was no longer acceptable in society once it was post-feudal, found a way round the law in order to give these people the status of free men. So what we saw in Don's address was that Magna Carta has certain principles behind it. The rule of law, due process, limits on central government, trial by jury, and I would add separation of powers, and the balance of powers between society and central government. Those principles, I argue, have become instinctive in our law. We don't now refer to Magna Carta, though I have to confess that I did find a reason to refer to it in a case in April about a rector. I shan't go into that, but I was able to cite both Clause 1, which is in force, and Clause 18, which is not, but it attracted a certain amount of attention in the press. But Magna Carta did migrate. It went to the United States. We've heard about that. It also went back from the United States back to Europe and formed part of the thinking behind the Declaration of the Rights of Man in the French Constitution. And I have to say that then it was the rights of man, they were not the rights of women, and we have to thank people like Mary Wollstonecraft who made the point that we should have rights for women too. And now no Frenchman, no French person would allow you to say that the Declaration de Droits de l'Homme does not protect women as well as men. but it originally didn't. And through the Declaration of the Droit de l'Homme, through Magna Carta, we have the Universal Declaration of Human Rights, which contains very much what you saw from Magna Carta, and from that we get the European Convention on Human Rights, and from that we get our Human Rights Act. Now, our Human Rights Act, as Professor Howard explained, does in fact preserve parliamentary sovereignty. It does not allow judges to strike down primary legislation, as in Marbury and Madison. That means that judges have to take a number of gymnastic steps to interpret legislation so it doesn't violate human rights, but they can never take that final step of declaring legislation to be contrary to the Constitution. So Magna Carta for us has never led to judicial supremacy. There is now a proposal for a Bill of Rights, but I very much doubt whether the position will change. But the secret that I want to put forward, the secret of what has really happened, is that Magna Carta has so influenced our law that it's become part of our natural, the hidden wiring of our law. We don't see the change. It's part of our national psyche to uphold those principles in Magna Carta, and it's why we have an unwritten constitution, because we have these unwritten principles so deeply in our national psyche. We don't have to write them all down in order to get them protected by the courts. So let me go back to my original question, which you probably worked out the answer. Is it a document or is it an event? And I hope you'll agree, it's an event. Thank you.
That wasn't the only event. These speeches themselves were an event today, I think. So that was breathtaking, and I really thank the panel. So now we have a few moments before, 10 minutes or so before we move to Talbot Hall for drinks, and I'll have the principal give us instructions on that in a minute, but I think we have time for some Q&A. So if we can have questions from the audience, and you can either direct them generally, and we'll ask one of the panelists to respond, or you can direct them to a particular panelist. Yes?
My question is probably for Lady Arden. Professor Howard spoke about judicial review, and I was wondering what your opinion was in terms of the impact on the rule of law of the recent parliamentary reforms on access to judicial review in the criminal justice and court.
So we're recording, and I'll just briefly characterize the question. The recent parliamentary reforms in the criminal area on judicial, not in criminal?
It's in the Criminal Justice and Courts Act, but it's on access to judicial review.
On access to judicial review, and does the Lady Justice Arden have a comment on that with respect to judicial review?
Can I just try and identify what I think the proposal is to which reference is made, and that is that the lawyer won't get paid for any fee unless the court grants permission to take proceedings for judicial review. Is that right?
Not just that the lawyer won't get a fee, but that there is the protected cost orders at the start, and that we're limiting when judicial review will be granted.
Lawyers will still have fees, I think I hear you saying, right? Okay.
Well, it is a matter of, as I understand it, of public funding, and there's also an issue about the government having said that there will be much larger fees to be paid by applicants who want to go for judicial review. The government certainly has published the view that it takes the view there is too much judicial review of public decisions, and that it stops important, for instance, projects to build HS2 or whatever, large projects of that nature. Can I just put it this way, that as a judge, I am just very concerned about access to justice. I think we have a real problem going forward, because the evidence is that in some cases, not just judicial review, but that people are now being unable to bring disputes because of the large fees. The Law Society was going to challenge the court fee, but has decided not to do so. But there is also a problem about public funding for civil claims. And I can only say that I agree with our speaker that this is a problem that the United Kingdom has to solve.
Very good. Thank you. Yes?
Can I ask what the panel thinks about the relatively recent view, I think, of one of our Supreme Court judges, Lord Sumption, who would say that the impact of Magna Carta has been grossly exaggerated. It is high-minded tosh. Looking at it from an English lawyer's perspective, it might be thought surprising that there are barely, over the course of the last 120 years, I think it's true to say, only 40 references to Magna Carta in the Superior Court. I didn't know Lady Arden's very recent one, so that makes it maybe 41. Compared, of course, to many hundreds in the United States. So it's quite clear there's an impact in the United States that hasn't perhaps been felt in quite the same way in this jurisdiction. It may be that it's hidden, as Lady Justice Arden had suggested, but I think it is surprising that most law students here will barely touch on Magna Carta.
So
they would learn about constitutional law, and it would be a minor reference to their understanding, or at least it was when I studied it 30 years ago.
So if I can summarize that as, what is the reaction of the panel to the suggestion the Magna Carta is full of sound and fury but signifying nothing, right? Professor Howard?
So I'm going to hand this to my
Suzelle?
professor, but there are over 1,500 references to Magna Carta in the United States case law. So I will now let the harder question be answered by Professor Howard. What does that mean?
Well, I think I perhaps could make the case that in American law and popular and legal culture that Magna Carta has a more iconic value than it does here in the country of its birth. And I told the story of how that affected thinking in the Revolutionary period and beyond. If you read American state cases between the founding and the 14th Amendment in 1868, there are pervasive uses of Magna Carta, not simply as a iconic reference, but actually as the basis for decision. I think that has died out over the years, more modern times, because it's become so much part of the fabric of the law. You wouldn't find a lawyer today, I think, going into court and basing an argument explicitly on Magna Carta. It would be on the progeny, on the descent from Magna Carta. And I would say, from my perspective as a professor, constitutional law is taught in a curiously ahistorical way in America. I referenced Marbury versus Madison. Quarrel with me, those of you who studied law in America, but if in the typical American classroom, you begin with Marbury versus Madison, as if the whole business sprang like from the brow of Zeus with John Marshall, as if nothing had happened before that. So when I teach constitutional law, we take about a week, starting in the 13th century, running right down to Marbury, before we ever get to what the U.S. Supreme Court has done. So I guess I have an ambivalent response to your...
So pass it down to Lady Justice Arden for just a moment, if you will, but while you're passing it, wouldn't it suggest that if it has become a part of the fabric or the hidden wiring, that you'd see less reference to it and that it would undergird the opinions? But Lady Justice Arden.
I think everything has been said. I was certainly aware of Lord Sumption's speech, which I found very surprising for someone who is such a distinguished historian in the 100 Years' War. In fact, what he had done was take one of the texts that had been used at the 700th anniversary, that of Professor Jenks from Liverpool, and build up on that to say it was all myth. Now, of course, it's fairly easy to make that argument at 1215 because it's torn up by Innocent III. But the fact is, it was cut and come again. Came 1216, 1217, 1225, 1230 something, and 30 times it was reissued.
All right. Next question from the recently elected, re-elected, overwhelmingly re-elected Lord Peter Bottomley.
Well, I'm not, she's the Lord, I'm not.
Everybody, the cab drivers are lords when we come to
See, two or three things worth us throwing in with a sort of question mark rhetoric at the end. The first is that what went into Magna Carta, besides the dispute and the help of the Archbishop, were rights and wants, desires that people had already. They didn't suddenly come off a shelf. No, they were there anyway. It wasn't the first charter, and it's the English, by which you may be British if you want to, or international. Is it fair? Is it right? Will it work? And I think that's so Magna Carta really got invented or reinvented by Cook, as the Professor told us. If he hadn't used the word Magna Carta, we still had most of what we've got anyway. And just the Americans wouldn't have printed all their judgments. The second issue is, I think that Mary Arden was absolutely right. We don't have to refer to things which are built in rather than bolted on. And the surprising question is why they keep referring to Magna Carta in the American judgments, but they haven't actually developed things which don't require that. And the last lighter thing is that the R's we were talking about, one of the reasons we're making a great deal about it now is the R for Robert Worcester, who's chairman of the Magna Carta Trust.
What about a comment on the first point that in this primitive document, these concepts were not invented at that time. The nobles hadn't come up with something new and creative, but they brought out the writing in lemon that became visible when you put a little heat on it. Someone comment on that, please?
I think you're right on the mark when you think about I can't consult the barons as to what they really had in mind, but my sense of the barons' demands, if they were responding to your question, I think their answer would have been, we're not making these up, we're not legislating, we're not inventing new rights, we're simply insisting upon something which we take to be the ancient Constitution. Now, I think in the process they no doubt added a little bit. I don't think they in fact were simply inheriting, but I think their pitch would have been, we're not asking for something novel or revolutionary, we just want you to respect what we already had. So I think in their mind, it was a conservative case they were making. So I think that picks up on your point. Sure.
Can I just correct something Professor Burrows said? I had to give a lecture on Magna Carta the 20th and 21st.
See who we are, Michael.
And I found there were 171 references. It wasn't a very promising treasure trove because most of them were references made in which the court dismissed this as being forensic folly.
Sound and fury.
And the real problem was that in the few cases where a serious argument was being advanced, the judges would always say, yes, but according to the law of the land. And the comment I want to make is, although we call Magna Carta a constitutional document, it simply lacks the very ingredient Professor Howarth identified at the start. It is not a document before which legislation will crumble. Parliamentary supremacy will always trump Magna Carta, and it therefore, to some extent, I'm on Jonathan Sumption's side, because I think its most important aspect is the heritage it gave to other jurisdictions and its really considerable mythic significance, which is identified by the fact we've got 4 such distinguished speakers again.
Here to celebrate his birthday. All right, very nicely put. I don't know if I can find a question in there, so let me go to Justice Mance.
Well, I absolutely agree with what's just been said and also with the hard wiring point. But I think it is interesting that, I don't know whether it's one of the references that either Andy Burrows or you looked at, in recent cases where we have had to address a really novel problem, whether there are any limits, it's a constitutional problem, to the impact of the application of the European Communities Act. We have looked back at emblematic instruments like Magna Carta and the Bill of Rights and asked rhetorically, have they enabled Europe by legislation or European Court of Justice by development of law to affect principles which are that? I think the problem will never arise with Magna Carta because the principles of impartiality and avoiding delay, injustice, and not removing people's possessions are integral to European law in any event. But there is a problem that arises under the Bill of Rights, which is a question whether we are entitled in court to question parliamentary proceedings. If European law suddenly said you must examine whether Peter Bottomley's committee is working properly, we would have some reluctance, as we said in the High Speed Rail 2 case.
Right. Well, the emblematic, yes.
I have a question, a thought for those who've been speaking about written constitutions, unwritten constitutions, Magna Carta, the underpinnings, the underwiring. It does make me think of brassieres, but I'm sorry. But wouldn't it have been interesting if there had been a John Marshall in England to deal with Magna Carta and the text of Magna Carta, because I just wonder whether John Marshall would have found a way to get constitutional supremacy out of the document. And the barons did think it was important to write it down and get it signed.
Could I just answer to a point made?
Yes.
Because Mr. Veloff was a very distinguished lawyer, made a point about Professor Burroughs, and I think I ought to come shortly to Professor Burroughs' assistance if he needs it. Firstly, and this is a general point, that Magna Carta did indeed draw, in essential respects, on what had gone before, particularly on the coronation oath of Henry II, which he had duly sworn to observe all sorts of rights, but had failed to do so. Hence, the need to repeat it in Magna Carta. But being a medieval document, it said lots of other things which have nothing to do with fundamental rights. But coming back to your definition, your point, I may, you have not defined for us what a constitutional statute is. A constitutional statute is a constitutional provision in a statute is one which gives a fundamental right. That's all the definition, and certainly you get that in Magna Carta. How you protect it is another issue. We don't have a doctrine whereby primary legislation can be struck down, but we do have a doctrine of implied repeal, that you cannot impliedly, Parliament cannot impliedly take away from a statute which confers a constitutional right, a constitutional statute. Once you see that, then we can see there are shades of meaning. I think we saw that at the end, if I may say so, Professor
Howell.
Our intervention.
One quick comment. It occurs to me that there was another might have been constitutional moment, a road not taken in England in the 17th century, in 1649, the so-called Agreement of the People, which was not adopted. The officer corps of Cromwell's army wouldn't have it, but the rabble in effect said, we want this agreement of the people. It would have, as I remember it, near the end there was a supremacy clause. It had a provision that said if acts of legislature inconsistent with the agreement of the people shall be null and void. Now, if that had been adopted, that would present the question that Suzelle has just advanced, namely, okay, you have a supremacy clause. Would judges then say, well, the way you enforce that clause is by judicial review? The agreement doesn't actually address that point. Since the agreement was not adopted, we'll never know the answer to that question.
I hope we're going to have some more vigorous discussion of these subjects with drinks. I do want to say this about any of these kinds of doctrines, and if they're events or if they're documents that become emblematic, sometimes there are two sides to that. They say the law school knife cuts both ways, and I can remember as a young lawyer getting up in front of judges, having an objection to make, and hearing something from a jurist who would never glimpse the footsteps of our Holmes or Cardozo or Brandeis or the judges of the caliber you're seeing here, and they would mumble something about judicial discretion, U.S. Constitution, Magna Carta overruled. So these emblematic doctrines tend to support views that you can pour into them at times. Well, let's continue that over drinks, and I will ask the principal if she'll come back up and give us, yes. Oh, I'm sorry. You're absolutely right. I'm passing over a very important point that we have here today. I'll call on Suzelle Smith.
So just stay up here for a second.
All right.
So this is a very special night for us, because this is the last Howarth and Smith lecture that we will give under the leadership of Frances Lannon, who is retiring, I think most of you know, as the principal of Lady Margaret Hall. It is a very sad, it will be a sad moment for us, because we have adored being part of the college with Frances, and she has been an extraordinary principal in so many ways that it would take me more time than we have, and I know everyone wants a drink, and Frances would kill me because she would be very embarrassed. But there will be no one, there's no way to replace Frances, and luckily the college has elected a new principal who just retired as the editor of The Garden and is Guardian, and his name is Alan. Thank you. And they didn't try to recreate Frances. It would have been impossible to do that. So it will definitely be a different era. But we will miss, all of us, Frances Lannon extraordinarily, deeply, and very much. And we want to recognize her amazing contribution to Lady Margaret Hall. There is a tangible way that we're going to recognize this. In Frances's humble way, when asked by some of her friends what we could do to honor her, she said she didn't want anything for herself, but a scholarship in history would be a wonderful way to honor her. And so there is a Frances Lannon Scholarship in History, which is almost completely funded, and that will be a small way to thank Frances for an extraordinary tenure. So if we could just clap for Frances. And in 2 minutes, we'll toast her properly with champagne.
Thank you, Frances. Can you come?
Yeah, thank you very much. Well, I want to thank our speakers again for such an interesting roaming around over many centuries of law and constitution making, and the fun of opening up some of these questions too about what the legacy of all of this really is or isn't in this country or in the United States or elsewhere now, whether it's so crucial and so significant we don't even have to mention it, or whether it's been rather left behind by all sorts of other developments. But I find, in the light of the very kind comments from you, Suzelle, which I'm very, very touched by, and Don, thank you so much. I have another question about Magna Carta. Does it say anything about the right not to be taken by surprise in an evening like this, please? So let's bring these events to an end here. And while we thank the speakers, I'd also like to invite you to come and join us for drinks and an opportunity to continue these discussions. And if you go out of the door here, you need to get to diagonally right in that quadrangle. Best to go around the edge because the grass will be wet. But you're heading diagonally right through to Talbot Hall. Thank you all again so much.